the Section 194 committee has recommended to the National Assembly that Advocate Busisiwe Mkhwebane be removed from her office as South Africa's public protector. The outcome of the process concludes 2 years of wrangling between the suspended public protector and the Section 194 parliamentary committee that was established to look into her fitness to hold office. Mkhwebane was presented to the process after Parliament took the decision in 2020, and this was not without a fight, as the public protector herself engaged in legal recourses at her disposal, trying to stop the process. We're now joined by Oliver Dickson, SAFM talk show host and political commentator, following the wrapping up of the committee's work. Oliver, a very good morning. Thank you so much for joining us. Welcome to Morning Live.
Good morning. Thank you so much for having me, Mr. Mkhwebane.
Oliver, what's your view on these drawn-out process, the hurdles it went through, whether it was justifiable or not, and whether it was just and fair?
Look, if you just look at the pure cost of it, right, we're talking here about tens of millions running into the hundreds of millions being spent just on Advocate Busisiwe Mkhwebane's battles against the presidency on the one hand and against the public protector, and of course, facilitating this parliamentary process. It is an enormously expensive exercise for an institution that is already cash-strapped. You must remember that this bill is being footed entirely by the Office of the Public Protector. And of course, there was an application for it to stop funding it, but pertaining to the parliamentary process, it had to continue paying it. And it took lots and lots and lots of money. And several times had to change representation. In fact, up until early this week, the Public Protector had once again changed representation in a parliamentary process. So if you were to ask, is it justified if the adjudication is just based on cost, then the answer is certainly no, it certainly is not justified. But more than that, the several amount of delays that took place throughout the process, one dragged it out so far along that it became futile as an exercise, because even if Advocate Busisiwe Mkhwebane were to win this case and were to be reinstated, let's say Parliament miraculously finds that she actually is indeed fit to hold office and the president has to reinstate her, she literally has 2 weeks left on the job or 3 weeks left on the job. And that certainly just doesn't make sense at all. I think what the political heads and the political actors should have engaged here was rather a settlement agreement much, much earlier that would have made it cheaper, that would have made it easier, and that would not have dragged it out this long. But what the value of this process, at least, has been is that this has been the first time that a Chapter 9 head has been suspended from office, and a fitness inquiry, an inquiry into a fitness to hold office has been conducted. We certainly are now learning about a brand new procedure in our democracy. Even though this procedure has been envisaged in the Constitution, it's never actually had been designed. And so you would remember where this process started is that court instructed Parliament to design a process through which such an inquiry could happen, and the validity and constitutionality of that process was first challenged by Advocate Busisiwe Mkhwebane. It then was that Parliament had to redesign this process so that it can be consistent with the Constitution. And that design work shows you just how much legislative work Parliament has not yet done in terms of building democratic institutions that very specifically pertain to accountability.
What I'm picking from your sentiment, Oliver, is that it has been a total waste of public funds. But then do you think this is the last we hear of this process, as the ad hoc committee is in the process of interviewing the 8 shortlisted candidates for the appointment of a new public protector?
No, I mean, Busisiwe Mkhwebane's case certainly will come up in the interviews. Very specifically, what you will note, and this is what came up yesterday in Advocate Tinyane's interviews, is that there is a sentiment, there is a concern and an anxiety, so to speak, to try and determine whether, preemptively, a priori, whether certain candidates are fit to hold office. And they're asking, unfortunately, the same set of qualifying questions that they asked Busisiwe Mkhwebane the first time around. Busisiwe Mkhwebane, on paper, made sense. She has the qualifications. They didn't quite test the experience, because if you really closely look at it, Busisiwe Mkhwebane never practiced law, right? She never had the forensics capability as a practicing attorney before a judge to be able to really sit well in this office. This is why, for instance, when compiling reports, she never preemptively thought, how would a court test the validity of this? And this is why she messed up procedure in investigations where she was involved in so monumentally. She would do things like issue reports without giving a right of reply. That obviously goes against a common practice and best practice, very specifically goes against natural law. And those sorts of tests can only really be tested against someone who has been to a court. But unfortunately, the committee in Parliament conducting these interviews is not the same committee conducting interviews of judges, for instance, which tests just that experiential question, right? And so there is a disparity in approach that I think can be narrowed through a lot more cross-pollination in terms of training, getting more professionals as we do with judges when interviewing judges, getting professionals and academia to be a part of the committee to ensure that we really stress test candidates thoroughly and making sure that they have the necessary forensics capabilities, but also the necessary practice and experiential skills to be able to sit well in this office and not give us reports that are half-baked, reports that are sloppy, and as the Constitutional Court once defined Advocate Busisiwe Mkhwebane's investigative processes, saying entirely confusing.
Now, Oliver, speaking of experience or the lack thereof and forensics capability, I mean, the acting public protector, Koleka Galega, is now one of the 8 candidates to be interviewed for this position. So what's your take then on the EFF's view that she should not be included in the process due to what the EFF says is lack of credibility and a cloud hanging over her head? I mean, of course, referring to her Phala findings when she exonerated the president.
So let's deal firstly with the Phala question, because that really is the EFF's bone of contention. It's a twofold bone of contention, right? The first is that the argument the EFF make is that, hey, this woman comes out of the ANC Youth League. We know her. We served alongside her. Now she's a public protector and a public servant, and she was previously legal advisors to several ministers. We don't think there's a level of credibility here. One, there may be merit to the question, is that she comes out of the ANC Youth League, does she hold some sort of allegiance to the party and its actors? That question can be dissuaded by asking her, are you still a card-carrying member of the party? We do that with other heads of institutions all the time. We do that with the Reserve Bank governor. We do that with the Statistician General. We do that with the head of SARS. For instance, Edward Kisvetter, who is the head of SARS, for instance, has a political history. Many of the heads of our institutions will naturally have some level of a political history that can always be mitigated against. But if they then say that had an impact on the public protector's report on Phala, they have to then evaluate the report on its merits. The last time I checked, it's nearly been 2 months since the public protector had released the Phala investigation report, and the EFF had not submitted a review application. In fact, it took the ATM, the African Transformation Movement, a party to this investigation, more than a month to submit a review application. Ordinarily, review applications to contentious public protector reports are submitted within days. Why is it the case that it took so long in this time? Because it's actually a really sound report. Procedurally, it's hard to fault the report. Where the ATM faults the report, and this is a legitimate point, is they faulted on interpretation. And that is what courts settle all the time, the interpretation of legal statutes, of words, of meaning, right?
Just briefly, Oliver, we are out of time, unfortunately. Remember that yesterday, the Section 194 Committee Chairperson, Kobudile Janji, spoke at length about the lessons learned, about the importance of getting the best people in those offices, quoting Kada Asmal's 2007 report about the need to fix South African institutions. So isn't it ironic, though, that despite all the reports, despite all the findings that we've been fed, South Africa is still going through the issues of perceived lack of accountability and flouting of processes of governance?
Look, we must recognize as well that we're still an incredibly young democracy. We're learning about institutional health, institutional wellness, and institutional configuration as we go along. For instance, we didn't know the limits of the Public Protector's Office until the Waterkloof and Nkandla judgments came out, and that was tested in court at the time. Thuli Madonsela was the Public Protector there. We learned about it as and when we went along, and that is indicative of just how incredibly young our democracy is. And so that's still going to happen for a number of more years as we ask ourselves the question, how is it that we best configure our state institutions, firstly, and how is it that we best exercise accountability? And we learn about accountability all the time in this country. But this is what is critically important. It is important that we have capable people at the helms of our institutions, and that really is the test for Parliament. But unfortunately, Parliament is poorly suited to stress test that question.
All right, Oliver Dickson, great chatting to you, man. Thank you so much for your time. I suppose we're still yet to see whether this report, was crafted. It was made because of Parliament's oversight responsibility, or it was crafted to see the actual outcome of it. Thank you so much for your time and for your sentiments. That was Oliver Dickson, SAFM talk show host and political commentator, discussing the conclusion of the Section 1 and 4 process. We just finalized this process and recommends the removal of Advocate Busisiwe Mkhwebane as the Public Protector.